this happens a lot of times, and I bet we have some law enforcement folks who watch this. Scuffle ensues. Maybe it wasn't started by the husband. We'll just use the male for argument's sake. Guess what? The man gets arrested. That's just what happens.
We are the Armed Attorneys. Today we are talking about the top 3 reasons you are going to lose your gun rights that aren't being convicted of felonies. Stick around. The first 2 are ones we see in our practice all the time, and they can happen to anyone. But before we get started, show your support for the Second Amendment by hitting the like button.
And it is so good to have Emily Taylor back. Hello, good to see you.
I'm so happy to be back.
Tell us, baby happy and healthy?
The baby is happy and healthy, and what's better? What's better than a fresh new baby?
Yeah. So, we're going to be talking about, we're talking about some disqualifications under 18 U.S.C. 922G, and I think a lot of folks, they maybe we don't want the world to be this way, but clearly the felon issue, the courts not really going in our favor in this direction.
No.
Although, we see some progress with the reopening of federal firearms relief. Maybe we'll see that early next year. Again, they're going to focus on folks who are dangerous, violent felons. But I think, there's some kind of pitfalls people fall into that maybe they're not aware of that really jams people up for losing their gun rights. It can seem very innocuous, and that's what we wanted to talk about.
Yes. So, number 1. Renouncing your citizenship.
No,
I'm just kidding.
No
one ever does that.
That doesn't happen. Although, can you unrenounce?
You can't. Remember, we had that. We had somebody call in once who had renounced their citizenship, then reclaimed their American citizenship and became a citizen once again through the actual proper channels and wanted his gun rights back. And you cannot unrenounce them for the purposes of gun rights.
It's like Michael Scott declaring bankruptcy. Once you yell it.
Nope, you're done.
You're done. No, but all right. What's the first one that you see folks in? And this happens a lot in our practice, and it seems not like a big deal, but it turns out, hey, guess what? You've lost your right to defend yourself.
It's a protective order, and this is, you think, well, I'm going to get a protective order because I assaulted someone, and they're going to. No. There are other ways to get a protective order. So the grand umbrella here is protective order.
Yeah, and we get this out of 18 U.S.C. 922 G8. And this is, and we'll just read this text so that everybody's on the same page with this. This is a person who's subject to a court order that was issued after a hearing of which such person received actual notice and at which person had an opportunity to participate, that restrains the person from harassing, stalking, or threatening an intimate partner of such person or child of such intimate partner or person, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner and child, and includes a finding that such person represents a credible threat to the physical safety of the intimate partner or child, or by its terms explicitly prohibits the use, attempted use, or threatened use of physical force against such intimate partner or child, would reasonably be expected to cause bodily injury. So where do these, obviously we got the criminal example out of the way, but where else does this come up?
Well, I will say before we get to the one that's common here in Texas, as I understand it, me being a Texas girl, there are states in which it is incredibly easy to get a civil protective order, which actually might have such language. So that's tough because you maybe haven't necessarily been charged with a crime, but in Texas, not the case. You have to be charged with a crime here to get a protective order that would read in this way. But where we do see them here in Texas is in your temporary orders when you get a divorce.
Yeah, it comes up all the time.
All the time. And it is not just Texas, but here I will tell you, your temporary orders actually have this exact language in them regardless. 99% of people who are getting divorced in Texas don't have a domestic violence issue at play, and yet every court, every judge, every time in the standard forms is going to include this language. So you're getting a divorce, you lost your gun rights while that order's in place.
Yeah, and so here's how to sidestep this issue, because a lot of folks, I'll say a huge chunk of divorce, nobody likes a divorce, but they're done amicably. Maybe they don't even have an attorney. They take the free form off the government website. It probably contains this language, so you have to be very, very careful. Or, hey, I'll tell, this comes up a lot with, let's say you own a gun store or you're an employee of a gun store. It's like, all right, you've unknowingly sleepwalked into the inability to earn a living now because you're going through this process. So it's one of those things. Maybe you need a divorce attorney. Maybe you want to bring these issues to their attention so this doesn't end up in a standard order.
Oh, yeah, no, because that is horrifying.
Yeah. So, all right, what's our number 2 reason?
Number 2 is your misdemeanor crime of domestic violence. However, that doesn't just mean that you assaulted your domestic partner and you beat him up and you were in court and convicted of it. It also includes the low level, ticket level offenses. If they are family violence offenses, they're going to get your gun rights yanked.
Yeah, and this is where, obviously folks think, all right, I'm in big boy court, I'm charged with a serious misdemeanor, felonies. Not really talking about those, but we'll throw them in here. All right, what people forget about is, traffic ticket level offenses. Think there's no way that you could spend a night in jail over this thing. You receive a citation or a summons, you got to show up. And what the federal government cares about is, does this have an element of force or threatened force? And who is that against? So it doesn't really matter what the crime is called. We're looking at the elements of the offense itself. And so
assault by contact.
Assault by contact.
That's what we're talking about.
Assault by threat. It could be a lot of different crimes. And if it involves, one of these intimate partners, and we'll just read the language, who's been convicted of any court of misdemeanor crime of domestic violence, that's all they say. Obviously, there's some additional explanation there, but if it has both of those elements in there, if you're just like, I'm going to pay the ticket and get this over with, well, maybe you've unwittingly signed away your gun rights forever.
Yes. And just so you know what we're talking about, and we're talking about, traffic ticket level assaults. I mean, and of course, I'm not encouraging these activities.
Emily loves wife beaters.
But it's things like, if you spit on someone, that's a Class C assault. You could spit on your ex-girlfriend as you're breaking up, and boom, you get convicted of that. You lost your gun rights. I mean, it's things like, it's any offensive touch or contact. So you put your hand on someone and you're like, hey, get out of here. And that person's a domestic partner and you get convicted. Boom, gun rights gone. I mean, well, in Texas, we have a Class B groping now. It used to be like, let's say you see your ex at a bar and you're kind of drunk and you give a little tushy squeeze and you get a ticket for that. Boom, gun rights gone. I mean, it really doesn't take much, y'all.
Or in self-defense cases, because let's say, and take the wife beater context out of this, you have inconsolable spouse arguing. Guess what? People argue. And this happens a lot of times, and I bet we have some law enforcement folks who watch this. Scuffle ensues. Maybe it wasn't started by, the husband. We'll just use the male for argument's sake. Guess what? The man gets arrested. That's just what happens, unfortunately. Even if you were defending yourself. It stinks.
As a chick, you got to be real crazy to be the one who gets arrested.
Yeah.
Extraordinary. Top 2% crazy.
It happens.
It does.
And we've seen it. But, self-defense cases, when people say, misdemeanor crime, domestic violence, it seems like they don't think about self-defense. Yeah, self-defense is implicated here. So you defended yourself, you think the whole thing's over with, you sign the ticket, you plead guilty or no contest or whatever. Maybe you've signed your rights away forever. Yeah. Now,
sidebar.
Yeah.
I read the comments, and while I was gone, I read the comments, and someone commented, and because Leslie is a gem and a delight, and someone was like, man, I really like Leslie better because Emily is a bit much. And listening to myself already on this first video back, is he right?
Yeah, he might be.
Am I a bit much?
Am I? I'm the problem. It's me. Hi.
I'm the problem. It's me.
Maybe. No. We love Emily. Now, the last one, and this one doesn't come up as frequently, and the courts are making a mess out of this one, but we aren't talking about felonies here. This is a person, and this is 922 G3, who's an unlawful user or addicted to any controlled substance as defined by Section 102 of the Controlled Substances Act. That's 21 U.S.C. 802. Now,
I'm looking at you, stoners.
Now, this is folks who, because what makes this one a little bit different is this isn't a person who's been adjudicated by a court. Think our mentally ill folks, people who've been adjudicated guilty, think our misdemeanor crimes of domestic violence, or protective orders where they've had an opportunity to be heard, kind of fight those issues out, or maybe avoid them altogether. This is folks who are just, maybe they like to get a little high.
Yeah, this is, you can flit your way in and out of being a prohibited person under this qualifier. I guess depending maybe on how much money's in your pocket. Am I right?
Yeah.
What you got to spend on drugs.
Sure. God. Yeah. Now, what makes this one a little bit more complicated, though, is the courts have done I'll say, overall very good job faithfully applying Heller, applying Bruin, applying Rahimi, which, Rahimi maybe was actually even helpful to the discussion of this issue because we have two things going on that the courts are doing, and really we'll point to the Fifth Circuit and the Eighth Circuit as examples here. We have the Fifth Circuit saying, hey, look, we need some nexus between intoxication and one other thing. And what is that?
Dangerousness.
Yeah.
Are you a danger? Which makes sense because there's no historical analog that I know of just like, you consumed a little too much ale and they said you can't have firearms
You're
anymore.
a lunatic. Get out of this place.
So
I mean, that's what the law looked like.
So, I mean, we had firearms Second Amendment restrictions. I mean, they weren't Second Amendment restrictions yet, but firearms restrictions at the time of the ratification for people who were dangerousness. I mean, we had sensitive places, we had, this and that, but really, we're not just restricting people willy-nilly without some level of danger. And so it makes sense to say, all right, druggies, you gotta also, be likely to hurt somebody, right?
Yeah. So, and again, that list of, let's say, prohibited places, much more narrow than the federal government is pretending that it is. This list of prohibitions in 18 U.S.C. 922, probably a lot more narrowly tailored than, if we look at the history and tradition of firearms, regulation, probably much more narrow, but there has to be, and this is the common theme that we're seeing, some intoxication tied to dangerousness. 80-year-old granny smoking marijuana for glaucoma. I don't know. Maybe a court says you're not a prohibited person. Person who every time they get intoxicated or consumes a drug goes on a dangerous wild spree endangering other people. Maybe a court in that scenario says, guess what? You are a prohibited person because we have those elements here. But you see that one's a little squishy.
It is. And of course, we have our temporal requirement as well, a la the Hunter Biden defense, right? Which is you have to be actively intoxicated at the time in order to qualify as a prohibited user. That is not necessarily the decision the courts have made, but that was his attorney's argument. But the courts have said, I mean, yeah, there is. It can't be that you were a prohibited user, last month and you're not anymore, and that's good enough. There has to be some sort of temporal requirement, but we just don't know exactly what that is.
Yeah, but we see, all right, not looking at serious crimes, putting felonies aside for a moment, you see how a lot of people could fall into these traps, especially think self-defense cases, think unwittingly divorce, think, all right, person, maybe they're intoxicated or they use an illegal substance, but maybe they're not dangerous. Does the court apply that? I'll say another note to throw in on the drug stuff is we don't really have that much binding precedent on this, and so your mileage may vary, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please leave us a comment or a question below. I'm glad to see y'all back. Until next time, we're the Armed Attorneys.
See, look at that. It's like riding a bike, except you don't know how to ride a bike.
I do not know how to ride a bike. I would not know.